order. We have two bills that we're going to take action on today. So I'd like to go ahead and get started if everybody could find their seats. I think is he going to testify with you? All right, guys, if we could take the sign-up sheet and actually place it next to Senator Burns over there, you guys can keep signing up. But I'm going to call Senator Still to present Senate Bill 191. I want to say welcome to all of our new friends in the building. It seems like we've attracted a different crowd today than usual. We have Senate Bills 191 and 196, which apparently are the Lobbyist Employment Acts of 2023. And we're going to hear from both Senator Still and Senator Watson. And I believe that all members of the committee have been heavily lobbied on both sides of this issue. Hopefully understand the basics of it. So I'm going to ask everyone today to assume that we have a 101 level of your issue. Senators Still and Watson, want to make sure you guys do a thorough presentation. But to those of you speaking in favor or in opposition, just want to let you know preemptively so you can plan. I'm going to run a clock, and we're going to be on 2 minutes for each person. So I want you to hone in on what you think is important. And there's not a ton of value in repeating what anyone else says. And then we will allow the committee to ask questions after everyone is presented, and then we will move on to any action that may be the will of the committee. Any members of the committee have any questions about that? Senator Still, is this your first bill?
No, sir.
Okay. Well, I was going to say I picked a school choice bill for my first ever bill, which had a different sort of hazing than the traditional hazing. But talk to us about Senate Bill 191, if you would. And Commissioner King, thank you for being here as well.
Thank you so much, sir.
Thank you, Mr. Chairman, committee, friends, colleagues, and all my new friends sitting behind me. My first bill was at 8 o'clock this morning, Mr. Chairman, and it was about the very exciting topic of leaf blowers. And you would think that this would be the spiciest bill of the session, but turns out this is not as much hate mail as I got about leaf blowers. So hopefully we can keep this one on track pretty well. Senate Bill 191 really came out of the idea that Georgia was one of only 4 states left in the United States that still allows plaintiffs' attorneys to seek damages from the actual insurance carrier. In any other industry, in any other method of a motor vehicle accident, when there is going to be a judicial or a lawsuit in some manner that there is a problem between 2 vehicles, you go after the policy of the company that the driver at fault has, right? So to explain it in the most basic of terms, Chairman Dolezal and I are in a car accident. I'm driving a commercial vehicle. I'm at fault. He should be able to seek damages against my policy. If the policy is maxed out, he may come after my company for some level of assets. This is the only industry in which he could also include my insurance carrier to try to be able to seek extra damages. And the history on this is based on the premise that when we had interstate truck companies and there was an issue as far as how to keep up with that company. There was an accident. How do you track that company down? How do you keep up? How do you pursue that? And so in the days before DOT tracking and digital tracking through weigh stations and interstate commerce to be able to have that, it was very difficult sometimes to find the origin, the insurance carrier of that company. we've progressed a little bit past that. We're not stuck in the 1960s and 70s when this first came about. And so we're trying to clean this up and make it in such a way that our laws are consistent all the way across. And the only people that have offered me any negative on this are the attorneys the plaintiff's attorneys who are seeking specifically to get maximum numbers of dollars. They want to seek higher damages than they would be entitled to in any other type of motor vehicle accident. And so I'm here today to work with you on this direct action bill, working with our dear friend, Commissioner John King, and he's going to explain a little bit further from a data standpoint why this is important, why Georgia needs this, why Georgia needs to catch up to the other 46 states in the country that are already doing this, and he can explain what this is doing to affect the trucking industry, the insurance industry, and small business owners across this state.
Thank you so much, Mr. Chairman, members of the committee. Thank you so much for allowing me to come and speak to you all. This is a department bill. This is initiated. We went and asked for the support of Senator to have this bill introduced because, first of all, I want to make sure that you all understand. I am the consumer advocate for Georgians when it comes to the insurance industry. I don't work for the insurance companies. I have no problem at all, and I have now a clear record of holding insurance companies accountable when they break the rules. But as I travel around the state for the last 3 years, I've been talking to folks all over Georgia. Small trucking companies are getting squeezed out of the marketplace, and because they can't afford insurance. And so when I talk to the companies who have left the state, I say, why did you leave the state? We can't operate in Georgia. We're being beat up unfairly. We're one of only 4 states in the nation that has this provision. And so you will hear a whole group of folks, pro and con, probably speaking on behalf and against this bill, who will give you, will give you the good, the bad, and the ugly stories. But only 4 states in the nation have this provision. I mean, if you think about who we're being joined with, the state of Louisiana has this provision. And I will tell you right off the bat, Louisiana has an increase in rates at 38.3%. No company can operate in a state that has those kind of losses. They can't do business. Large motor carriers can absolutely operate because they have big overheads. But small, veteran-owned companies that are just starting off, that want to get started, they can't afford $15,000 to $17,000 per truck insurance. They're getting crushed. I want to talk briefly about what this bill does and what it doesn't do, because you will hear a lot of information. And I'll tell you, I kind of wish folks that came and testified with you would have to swear to tell the truth, because there's a lot of smoke that gets tossed out. I've been in a couple meetings lately, and like, mother of God, you know. I still remember, Senator Anna Matarda sitting in the Doraville City Council with me, and the children. I start hearing the children, and mother of God, it just, the end of our nation is resting on this. But I want to make sure that, I come across companies that are just trying to start off, especially veteran-owned companies. We're one of only 4 states that has this provision in existence. Senate Bill 191 it treats for-hire truck companies the same way we treat every other business in the state, by removing their insurance company as a named defendant from the caption of a lawsuit. This legislation does not cap judgments. I want you all to keep that in the back of your mind. It does not cap judgments. It doesn't make it more difficult to track down truck drivers. We can track truck drivers. 46 other states has no problem with tracking truck drivers to serve them. It doesn't prevent anyone from receiving their fair day in court. And that is something that I am passionate about. Everybody deserves their fair day in court. And nobody's trying to remove. This will not remove that provision. I've been now commissioner almost 4 years. And I've been approached a number of times by insurance agents, trucking companies, and even members of the General Assembly. They're asking, what can we do to bring truck insurance rates down? Repealing the this statute is the simplest and most effective way to address these business this industry. I'm not guaranteeing you that our rates will drop dramatically. What I'm trying to achieve is the companies who have left the state. We're now only have 5 major carriers to offer trucking insurance. There's other ways to get insurance but they're cost prohibitive, averaging about $15,000 to $17,000 per truck if you go to a surplus line. And so what I'm trying to do is bring companies that left the state to return to the state and compete for the businesses of small trucking companies. And we feel that this is the least intrusive way of stimulating the market to get those companies to return to the state, because they're leaving the state.
Thank you, Commissioner. You've got a couple of questions here, and I want to
Yes.
make sure we keep this meeting moving. And I'm going to give each of these members one question, and then we'll
Sure.
move on to testimony. Do that, Senator McLaurin.
Thank you very much, Mr. Chairman, and okay, it's on. Commissioner King, thanks for being here. Thanks for your historic achievements, and respect everything you're saying. By way of quickly framing the question, I feel like on this issue, there's a lot of first and last, black and white. There's sort
Yes.
of best state in the country to do business, judicial hellhole. We're only one of 4 states to do it, but sometimes when we pass, citizens arrest laws, we're the first state in the country to do it, so we're a leader, right? So the narrative, I feel like, can kind of go back and forth, and just as plaintiffs' attorneys might frame the issue one way, your information is straight from the insurance companies, right? So I think
Not
well,
necessarily,
well,
sir.
really
I would
quickly.
disagree with that assertion.
Oh, okay. Well, I'm just saying some of the evidence you cited, but the reason I frame it that way is I want to say I think there's a lot of both sides element going on today, and what I would like to ask is, do you agree with me that the best way to get through this discussion is to look at how and why insurance companies are actually forced to set their premium rates the way that they do, and to have the most sensible policy discussion we can as a committee about what keeps those rates low versus, what keeps them high? Isn't that the focus of our discussion today more than anything?
I would disagree with that, sir. I think this is our approach, as this bill is a department bill. Our approach is to be develop the least intrusive method of being able to bring companies back to the state, and through competition, through free market, to be able to get more companies to compete for small trucking companies' policy, to sell those policies, to stimulate, to get the rates lowered. Now, if we continue going down this pathway with the pressure there is on the trucking industry, basically those rates, if companies have to pay more rates, those get passed on to the consumer. So every consumer is paying more from products they're having to purchase every day in the supermarket because their insurance costs are increasing. They're not going into a magic sphere of where, this just comes into the deep pockets of companies. Insurance companies vote with their feet when the state becomes, and if we only one of 4 states, and I'll tell you, the comparison, us being in the same boat with Louisiana, I don't think it's a great strategy as a state to be able to maintain our #1 place to do business in.
Thank you, Commissioner. We go to Senator Mello, or is that Senator Beach? Senator Mello? Senator Beach.
Thank you, Mr. Chairman. I am from Louisiana, so it's a pretty good state. But anyway,
Not if you're a trucker, sir.
no, not if you're a trucker, I guess. But my question to you is, we've got 5 carriers, you say.
5 major carriers. Now, there's
So-
other ways to get an insurance, but I would say that those were almost cost prohibitive if you're a small trucking company with less than 5 trucks.
So my question to you as our insurance commissioner, if we pass this legislation and it gets signed by the governor, do you have a game plan to go out and try to recruit 5 or
Absolutely.
6 more carriers? Because if you don't, the rates are still going to be $15,000
Absolutely.
if we don't get competition. So do you have a game plan to go out there and sell that to the carriers to say, please come back?
Part of our analysis, Senator, is we went to talk to the companies that left and asked them, why did you leave? And would you be willing to return? And they probably shared with us that they would be, because Georgia's a great market to do business in. And I have, folks from the Independent Insurance Agents Association that will be able to give you some hard data of how the market is posed right now. But the companies have all indicated that will return to Georgia because this is a great place to do business. But this is breaking their back, especially companies that are less than 5 trucks. That's the target area that I'm trying to influence.
Senator Moore.
Thank you, Mr. Chairman. Commissioner, thank you for all the work you do. I think you're absolutely right. I mean, this is certainly costing a lot of Georgians a lot of great opportunities. My father started a trucking company back in the early 90s. Insurance rates in Georgia put him out of business. I talk to constituents all the time who, they become outlaws, essentially, right? They don't put the motor carrier compliance number or the USDOT number on the side of their truck anymore. They just call themselves independents because they don't want to purchase commercial motor vehicle insurance because it's so expensive. You say that these insurance companies have left. Why have they left?
Because the market is making it, the first example you outlined, there's a clear provision in the law, criminal law, that you have to have those notices on the side of every truck. And then we have the Trucking Association behind me that will probably be able to get into
That's right.
a lot more detail
Yeah.
into that requirement. But the market is basically, they can't compete.
But doesn't an insurance company and their client, the trucking company, both agree on a set upon premium and a cap of insurance policy, right? I mean,
Yes.
they're in agreement to that. So why is an insurance company immediately settling when they have a lawsuit? Why aren't they fighting this in court?
Sorry, I will definitely let the lawyers talk about legal strategy. I can tell you, I'm probably a really good chief of police. I'm a really good insurance commissioner. I'm a pretty decent soldier, but I'm not going to try to pretend that I'm a great legal strategist. I usually, when I would go into court as a chief of police, I would beat up my insurance company. I blame Senator Anretardo because he was sitting on our city council and he would agree with the law firm to settle when we knew we were right.
Well, with
But
that in
lawyers
mind,
and
with that in
insurance
mind,
companies don't
Commissioner,
make-
we're going to go ahead and hear from some lawyers. I think there's
I'm
one or
sure
two,
you will.
one or two of them in the room. So we're going to go ahead and ask you guys to step back. Thank you for your presentation,
Thank you so much, Mr.
and
Chairman.
we'll bring
I
you back
appreciate
up
the
at the
opportunity.
end. Ed Kroll, you're going to be up next, and then Bob Fuller, you are on deck. So Ed, you can step forward, and as a reminder, each of you guys have 2 minutes, and I will let you know when your time has expired.
Thank you, Mr. Chairman. Again, I'm Ed Kroll with the Georgia Motor Trucking Association. We are the largest trucking association in the state. We represent all facets of the industry. We're about 90 years old, and I can shorten my testimony a little bit by saying everything you just heard from the commissioner is in fact accurate. This is killing small trucking companies. It is forcing people out of business when they get their renewal rates, even though they've had no losses, even though they've had no claims. And it is directly related to this issue. We mentioned already 46 states do not have this law. There is no trend for it to grow. The trend is for it to be repealed and taken down. As you made a good point, Senator, sometimes we're first to do something. We're on the back end of this. Everybody else understands it. I think there's a couple of fallacies we have to address. One is the idea that people who do not create the insurance product or do not sell or buy the insurance product are somehow experts on what the impact of this insurance product, what the impact would be to insurance products if this law changes. We know. We will see it drop. Senator Beach, insurers will come back. We have trucking companies they want to insure and that they do insure when they operate in other states. So we want to have them back. I'm trying to stay inside my 2 minutes. I'll be happy to answer any questions. But we were told the other day that this was needed because truck drivers are transient. Well, my goodness, who isn't? We got a huge ag community that's full of people who are transient. Hotel and motel people are transient. We love our film industry. There are so many people in that industry that are transient. There is no excuse for this law to exist targeted only at for-hire trucking companies. If it did not exist, you would never pass it. It is bad public policy. It's time for it to be done away with. Thank you.
Thank you, Mr. Kroll. Next up is Bob Fuller with Fleet Risk Management, and Brandon Peace, you are on deck.
Good afternoon. My name is Bob Fuller. I'm with Fleet Risk Management Assured Partners out of St. Simons Island. And I've spent the last 28 years of my career insuring trucking companies, exclusively trucking companies. My office in St. Simons represents about 2,000 trucking firms, about 1,500 of which are in Georgia. Our client group would track closely the ATA statistics, which is 92% of truckers in the country operate less than 6 trucks. 97% operate less than 20 trucks. So this is a small family business, and those are the folks that we're here representing today. I think it would be helpful perhaps if I mention how a trucking company acquires its authority to operate. This is the interstate process. The intrastate process tracks similarly. There are three things that are required. The first thing is the application that you make with the Federal Motor Carrier Safety Administration. Includes where you're going, what you're going to do. The next item is an MCS 90. An MCS 90 is a certificate of financial responsibility to the public, and it represents the guarantee of the insurance carrier to the public that the claims incurred by the trucking company on whose behalf it is issued are paid by the responsibility of the insurance carrier. The third item is called a BOC3 form. The BOC3 form is required for every trucking company that operates in the country to provide a service of process agent for every state, whether they enter that state or not. So if this business about a trucker coming in from Oklahoma is involved in an accident, disappears, and we have difficulty finding him to perfect service, is actually dispelled by the fact that the BOC3 form requires that they designate a representative in Georgia to receive service on their behalf. In 28 years, we've never had an
You
issue.
got 5 seconds, Mr. Fuller.
5 seconds, okay. Rates will come down when losses come down, and that's what we're trying to do. This statute exists to increase jury awards to plaintiffs that are suing trucking companies. That's the only reason.
Thank you, Mr. Fuller. Brandon Peace, you're up next, and then Dan Snipes, you are on deck. Mike Iverson, you're in the hole, by the way, to keep the baseball analogies going. Hello, Mr. Peace, you can go ahead.
Good afternoon, Mr. Chairman. Brandon Peak. I'm a lawyer from Columbus, Georgia.
Did I say Peace and it's Peak?
That's okay.
My apologies.
No, I've been called a lot worse. First of all, I want to address something that Senator Steele raised. This direct action statute has nothing to do with increasing the amount of jury verdicts. The amount that a plaintiff is able to recover in a direct action statute is limited to the amount of the insurance coverage, period, and it's only the first level of coverage. There is no scenario where changing this law affects extra contractual damages. I want to address the key issue of getting someone served, because it is an issue. And I had a lot to say about this, but I don't have time, so I want to tell this story. This law has been on the books since 1937. I was hired to represent the family of a young woman named Mallory Beach who lived in Lookout Mountain, Georgia. She got up one Saturday morning to take her daughter on a hike, and while driving back up Lookout Mountain, just inside the Tennessee border, she got killed by a 32-ton tractor trailer. Killed her, trapped her in the vehicle, poured acid on her daughter, who watched her die in the back seat. I reached out to the lawyer hired by the insurance company and asked them to accept service on behalf of the driver, who was a Texas resident and fled. You know what the answer was? No. The driver went on the lam. We chased him around for months and months and months of him trying to avoid service. If that happens in Georgia, we can utilize the direct action statute to sue the insurance company directly. That's not going to cost them any more money. The claim is limited to the amount of the policy limits. Senator Beach, you asked about bringing companies back to Georgia. The direct action statute applies to insurance companies whether they're based in Georgia or not. We got insurance companies or truck drivers from all over the country coming in and out of Georgia every day, I-75, 85, 95, the port. It applies to them as well, for the very reason that they're transient in nature.
That's your time, Mr. Peak.
Thank you, sir.
You can tag team, I believe, your coworker there, because you both have GTLA here on your on the sign-up sheet. So Dan Snipes, Mike Iverson, then I'm going to butcher the last one, Mark Bardak, perhaps, with Freeman Mathis and Gary.
I'm
Thank you,
Dan
Mr.
Snipes.
Hey, Mr.
I'm an
Snipes.
attorney in Statesboro, and I was president of Georgia Trial Lawyers Association in 2019 and 2020. I want to talk about something kind of basic on this, but in order to create more competition for carriers, it's a much bigger process to have more carriers. It's a much bigger process than changing this statute. We have neighboring states that have state-funded reinsurance programs so that insurance companies can set off some of the risk from an individual policy. Because direct action does not increase the risk of an insurance company, it's not going to do anything to change what their potential losses are. But premiums for insurance companies aren't based on just, and their profits of insurance companies aren't based on the difference between premiums received and claims paid out. Insurance companies are very sophisticated entities. They are huge market investors. When they set aside reserves to pay claims, that money's banked aside, and then they make investments. The companies that write this kind of insurance in Georgia make billions of dollars. They're making a decision to oppose this statute because it's just something they don't like. But it's not going to have one bit of difference on what premiums are priced in Georgia.
Did we just have a lawyer go under on their time? Let me check Mr. Snipes, thank you very much. That was almost half the allotted time. Appreciate you. Mike Iverson.
All right, I'm Mike
Mark.
Iverson. I'm the president of the Big I. I also work with ISO on coverage issues and recommendations, really from a consumer advocate standpoint. So all your insurance policies have ISO on them. In addition to that, I guess I just want to hit on, first, we're talking about not trucking. We're talking about a small sector of trucking, for-hire truckers. So there's a discrimination in the law that basically speaks against for-hire truckers. And what does that mean? It allows the insurance company to be named. And so if you look at any of the attorneys who probably were here today and you look at their website, you're going to find language on their website that talks about as soon as we name the insurance company, we get more settlements. So to think that it doesn't impact the market is just not to look at the fact that you're biasing the jury right out of the gate, which is a prejudice to know that there's an insurance company involved. Now, what do we look like compared to other states? I think that's as useful. What do the neighboring states look like? Georgia, our rates compared to South Carolina were 35.3% higher. What do we like compared to Alabama? We're 60% higher. What do we like compared to Tennessee? We are 71.5% higher. What do we like compared to North Carolina? We are 98.8% higher. What do we like compared to the rest of the nation when we take Georgia out of it? We are, it's an awful number, 66.6% higher. So to think that there isn't an impact in this state, and if you speak to the insurance companies who we had one that we lured into the state recently, who had a direct action case, and they said, man, we thought we understood direct action because we're based in a state that has direct action. It is not used in Georgia like we're used to in our state. We're done, and rightfully so. And as to the idea of insurance companies making billions of dollars, yeah, I think the industry does make billions of dollars. Do they make billions of dollars or even millions of dollars in Georgia? The statistics say not. Because if you pull the data, which is right out there, you're going to find, I think the loss ratio last year was around 114 or 116%, which means for every dollar they wrote, they lost $1.16.
You've got 10 seconds, Mr. Iverson.
So if we think that's a healthy environment, then leave it. But if you want to protect Georgia, we need your help.
Thank you, sir. And our last speaker is going to be Mark Bardak with Freeman Matheson Gary.
Thank you, Mr. Chairman, Senators. I'm Mark Bardak. I am a partner with the law firm of Freeman Matheson Gary. My practice is primarily representing trucking companies on behalf of their insurance companies in truck accident litigation. I want to specifically address the comment that, or the argument that the direct action statute doesn't result in increased verdicts. And I would say to you that that is really the only real benefit that the plaintiff's bar gets from it. All of the other things, service, you still have to serve somebody, you still have to prove your case, all of these things. In any other case, liability insurance is not admissible. I mean, that is black letter law. And yet we allow it in these trucking company cases. The reason it's not admissible in other cases is the belief that the jury, knowing that there is insurance, tends to increase verdicts. And yet in these trucking cases, we allow it. The insurance carrier is on the pleadings, they are on the verdict form. That only reason can be, and the only benefit is to increase the verdict. And this idea of, well, you know, they're only liable up to their limits. That's true for the primary carrier, but the jury doesn't know about the limits. They're not told that. They just see Nationwide Insurance or AIG Insurance on that verdict form. And that, you know, given that that's not allowed in any other type of case, that's fundamentally unfair. I also want to note, everybody's talked about this affecting for-hire companies. I will tell you, as a matter of practice, plaintiffs' lawyers are applying this much more broadly, or trying to apply this much more broadly, and trying to, and are suing insurance companies, naming them on complaints, in not just for hire cases, but where any commercial vehicle is involved.
Thank you, sir. You're
in
right on
part
time.
because the statute, the way it's written, is very unclear.
Thank you to everyone who took the time to be here and to testify. Are there any questions from the committee for the bill's sponsor? I see a question from, is that Senator McLaurin, number 10?
Thanks, Mr. Chairman, and thanks to all the presenters. I think we have the resources or ingredients we need to sort of have a full discussion. I mean, and I'm just going to, again, by way of framing, sort of tell you what my thinking is and see if you have a response for it, because I really want to discuss this in good faith. If the policy limit determines what the insurance company is liable for, ultimately, right, whether it's, because this is a procedural mechanism, right, to allow the joinder of a party as opposed to increasing their substantive liability in any way, I guess my question would be, how can you say that losses are worse without saying that either, number one, juries are making a decision to award more damages because it's an insurer, or two, that we're basically, subsidizing the verdicts that plaintiffs can get by omitting the ones where they can't obtain proper service. I'm asking if there's any argument for losses beyond those two arguments.
Without being an insurance agent or an attorney such as yourself, I can't answer that. What I can answer is this, because I own a construction company, but I do not own a trucking company, so I have zero skin in this game. What I do understand is this: when you have an increase in claims, you have an increase in losses, you have an increase in outcomes, you have an increase in rates as a result of it. And I think that the figures that we were just told about result in that. There's a direct correlation in Georgia between an increase in judgments and what that relates to in terms of premiums that are paid by the company. That is what this is all about. And to answer your question with a question, if there was truly an honest conversation about this among the parties that just testified right now, something is very much missing between the folks. And I'm just going to tell y'all right now, among the people that testified, there's a huge gap in what is happening here. And Senator, I say this as my colleague and my friend, you and I have to figure out where the truth lies in the middle of that. But the irrefutable fact is this: when these claims continue to skyrocket because juries are allowed to and encouraged to swing for the fences because they can, because they've got some massive insurance carrier sitting on the other side of it, that drives companies away, and it is bad for business in Georgia.
Thank you, Senator. I'm going to recognize Majority Leader and the next item, number 13. Is that you, Senator Gooch?
Yeah, I'm prepared to make a motion at the appropriate time.
This would be the appropriate time.
I'll make a motion we do pass Senate Bill 191, LC number 442335.
I think we had a premature second before that motion, but I have a motion to pass in a second. Any discussion from the committee? I see number 10, Senator McLaurin. I think actually, Senator Mello, your light was on first.
Absolutely. Thank you, Mr. Chairman. And to members of the committee, having served on a civil jury trial, I think that for these matters to talk about what a jury may or may not award is truly the litmus test of our society, that if you do have a tort in this country, you bring that to a trial before a jury, and you present the evidence of your case, and the jurors will hear the evidence based on the preponderance of the evidence, much higher than reasonable doubt, and they will make an informed decision. And so if this bill is to take power away from the litmus test of our society, which has been held as a jury trial, I would ask my colleagues to vote no on this measure.
Thank you, Senator. Senator McLaurin.
Thanks, Mr. Chairman, and I'll try to be extremely brief, but my thinking on this is basically, this is a procedural bill. It just changes who you can join in the action. It doesn't change the substantive liability or policy limits of the insurance policy. So if the argument is, as the sponsor just articulated, that I think the words were more claims eventually mean more losses, what that in effect is saying is that if we're reducing our amount of losses because we can't serve somebody, we can't get the lawsuit going, that saves the insurance company's money because they're unable to bring a claim at all. I mean, essentially what we're saying is if somebody has a valid claim, Mr. Peake told one of many stories that plaintiffs could tell in these cases. The argument is essentially if we make sure that person doesn't have a procedural mechanism to bring their claim, insurance companies will lose less and rates will go down. I mean, that's putting aside the question of whether rates are actually determined by this, because I think these are complicated, algorithms that insurance companies have resources to figure out, and they can price premiums appropriately, per client. The thing that really disturbs me about this bill is the idea that we're trying to save money in Georgia and, quote, protect businesses by denying valid claims just by virtue of a procedural defect that we can't find somebody to serve. If that's really the will of the committee, I mean, I just want us to admit that that's what we're doing, is that we're trying to save money by denying people their ability to be made whole. That's not how I want to get to a state of competitiveness in the state of Georgia. I would love to look at other solutions to try to keep rates down other than denying valid claims. Thanks, Mr. Chairman. That's why I'm voting no.
Thank you, Senator. We have a motion and a second. All those in favor of the motion, please signify by raising your hand. I have 7 yeas. All those opposed, like sign. I have 4 nays. Motion carries. Miscount? I misunderstood. See? My apologies. My apologies. My apologies. My apologies. I would say I missed Senator McLaurin, but nobody would believe that because he made his position clear. So we are going to move on to Senate Bill 196. And I saw Dr. Watson in the room. Thank you, Doctor, for coming before our little committee here today.
Yeah, thank you.
We are not often blessed with the presence of a man of your stature and gravitas and credentials.
Yeah.
Talk to us about Senate Bill 196, if you would, and there's 2 people that have signed up to speak in favor, and we've got 19 minutes. I would encourage you to, if you want your bill to have action, I would encourage you to take about 5 minutes to discuss it.
Thank you. I can take less. This is, if you're looking, let's make sure we're talking about the right bill that's in the folders. Senate Bill, that's 196 LC 393778S. Is that where we are?
Yes.
So this bill is rather straightforward. If you'll look at section 3, line 65. This is whether or not seat belts can be entered in litigation, whether or not it can be entered, whether you're wearing it or whether or not you're wearing it in civil litigation. And that's what it boils down to. Questions? That's pretty straightforward.
I see a question from Senator Moore.
Thank you, Mr. Chairman. How do, I've been in accidents before, and you get your report back, and there's, the trooper will mark, whether the driver had a seatbelt on or not. But typically, the trooper, or the police officer, is just basing that on an assumption, or maybe they saw. I mean, how do we prove that someone's wearing a seatbelt or not in an accident?
Well, let's separate this out. You're talking about, and I'm no lawyer, and we'll have lawyers testify. Maybe it would be better if we had someone come up and answer that question,
Okay.
Rather than let me conjecture from that standpoint. So why don't we just hold on that and answer any other question, then we'll get the lawyer to answer that.
Senator Gooch.
Go over section 3. Why did you strike lines 37, 38, 39, or 37, 36, 37, 38? Still with the seatbelt exemption on farms.
So if you look at lines 62 through 64, that's just placing it in a different section. Just all. That's right. And if you look on lines 45,
we're still preserving the right for off-road vehicles and farmers to not be.
that's right. And that's why you're being detailed. He told me 5 minutes, so I probably just, by not addressing that, I just increased the amount of time we spent on that. But thank you. Yes, thank you very much.
Senator Burns.
Thank you, Mr. Chairman. Just a quick question. When the trooper reports whether a seatbelt is in use or not, is that at the time of the accident, or is that at the time that the trooper?
Yeah, same question there. We'll answer that as soon as the lawyer gets up here. If you don't mind.
Same time as, say again, please.
So let's answer that question when we get a lawyer up here. that may know the
Okay,
answer.
thank you very much. We'll defer.
All right, thank you, Senator Watson. We have two people signed up to speak. The first is Hunter Loggins and a member of NFIB, it appears. We'd like you both to step forward, and if you do have a member, would like that person to state their name as well. And then Robert, I believe it looks like Snyder, whose handwriting is about as good as mine, I think that's correct, from GTLA.
Thank you, Mr. Chairman. My name is Hunter Loggins. I'm the State Director for National Federation of Independent Business here in Georgia. We have over 6,500 members, all of them small independent business, most of them mom and pops with 10 or fewer employees, and a majority of them with small fleets and trucks, similar to the demographic the commissioner was mentioning earlier. I won't take up much of your time because I do have two members to speak on this issue and how it impact them, so I appreciate your favorable consideration. You guys want to come up?
Thank you guys for being here. If you don't mind stating your names, and then you each will have 1 minute.
Go ahead.
May Whiteside Williams.
John Samdeman.
Oh, sure. Again, I am a small business right here in North Buckhead. My business is also located in North Buckhead. I am a civil engineer. I've been practicing for 22 years. I have a team of 25 engineers. We all use a fleet. I have a fleet for construction inspection of local roads and streets, and our vehicles make frequent stops. We have to get out and inspect road and highway pavement, bridge inspection, things like that. And so the bill as it's presented, as it stands, I support it because, you know, with the protection of our engineers and our firms, if someone were to hit us and they don't wear a seatbelt, it's easy for them to come after me. And to be honest with you, I don't have that kind of money. Attorneys cost over $400 an hour. And that would literally, going through a bunch of litigation, would probably put my business in a negative cash flow. And we all know when we're working with local units of government, sometimes payments can be slow, and I may not be able to support it. So the way the bill as it stands, I support it as it stands.
Thank you.
Right, and my name's John Sandeman. I'm CEO of Sampson Tours Incorporated here in Atlanta, 40-year-old family-owned business. We have a mixed fleet of motor coaches and school buses. And I can tell you rates have risen dramatically for our industry. We're currently paying about $23,000 a year for one motor coach. That is directly due to a lot of litigation that has exploded in the recent years, and this bill, which I do support in whole as it stands, would help to prevent some frivolous lawsuits from happening. I have seat belts on my equipment, and I have video that I can prove whether or not someone was using it. And we've actually had cases recently where a car T-boned my school bus going 60 miles an hour and knocked a little girl out of her seat. Everybody was fine except for the car driver. It wasn't our fault, but now they're trying to sue me for some mysterious damages that never occurred. I've had a case that went to court, well, was going to go to court, and I went to a mock jury trial where a person was run over by a car, not me. We weren't involved. We were nearby, but because they were trying to get to me, they're trying to sue me for $10 million. The mock jury trial had rates as high as $130 million. So that speaks to, yeah, it's not, they can only get what the insurance provides, but they can go back to me for the balance, and then that'll put me out of business.
Thank you both for being here. Next up is Mr. Snyder with GTLA.
Thank you, everybody. My name is Rob Snyder. I grew up in Lawrenceville, Georgia. I'm an attorney. I represent plaintiffs in lawsuits related to car crashes, product liability cases. When I think about the seatbelt rule in Georgia, I was kind of thinking back to what the commissioner was saying about how he believes Georgia is an outlier with respect to the direct action statute. Well, 29 other states have the exact same rule that Georgia has, that evidence of violation of the statute of not wearing a seatbelt is not admissible into evidence in 29 other states. 7 states allow it in, but they cap the amount that the damages can be reduced somewhere between 1 and 15%. The rest of the states don't allow it in for everything. There's only a few states in the country that would do what this bill does, which is allow evidence of seatbelt non-usage in every case for every purpose, and that includes child car seats. And so I just wanted to point that out, that this is not an anomalous statute. This is not something that only Georgia has. It's also not a problem in most cases. Seatbelt usage is at its highest that it's ever been. Something north of 95% of people who are in wrecks are wearing their seatbelts in the front seat.
You do have a question, if you'd like to take it.
Sure.
Give the committee one guess who the question is from. It's our lawyer.
The chairman and I are developing a mutually respectful relationship. I enjoy the Senate. Thank you. Mr. Snyder, I think it would maybe be helpful for the committee to kind of understand the balance that we're trying to strike in terms of what's admissible and what's not. I mean, if I T-bone you in an accident and I get cited by the police for that accident, is that admissible?
That's not admissible even if you go to a jury trial and are convicted. That also is not admissible.
Okay, so I guess to the point then, I mean, in terms of balance, you're arguing that the admissibility of the evidence we're talking about is kind of treated the same way currently under the law. There's balance on both sides of the V, correct?
Absolutely. And I would also say that because this is a problem in such a small number of cases, what it's going to do is create a problem in most of the cases where everybody is properly wearing their seatbelt, because lawyers do what lawyers are going to do. They're going to defend their client. They're going to try to prove that somebody is not wearing their seatbelt. What's the first thing that you do when you're in a car crash if you're not catastrophically injured or killed? You unbuckle your seatbelt, you check on the people in your car. If you get out, you check on the other cars. So when the police are arriving, they're going to ask you a question. They're going to say, were you wearing your seatbelt, yes or no? The person who hit your car may get out and say, well, I saw them walking around afterwards. They weren't wearing their seatbelt. Then you've got to figure out how to prove it. It's not as easy as just pushing a button and proving whether you were wearing your seatbelt. And so it's going to make cases, the majority of cases where people are properly belted, more expensive and more difficult for everyone, which is not good for anyone, including insurance companies.
Thank you, Mr. Snyder. We did have one last minute sign up here from a Mr. Lee Mickus, I believe it is. Nice you to step forward.
Thank you, Mr. Chair. My name is Lee Mickus. I am here on behalf of the American Tort Reform Association. I am a lawyer from Denver. I have a national product liability practice where I litigate seatbelt issues around the country, including in Georgia. I'm here to encourage your support for Senate Bill 196 because this is about trusting juries to hear and consider the whole truth about a crash scenario and not forcing them to make decisions on half-truths. In my experience, when I talk to juries after trials, they all want to know the answer to this question: was the plaintiff wearing a seatbelt? I want to address a few things that you've heard maybe today or maybe in the hallways about what this bill is all about. We've heard some discussion that there has been a determination that seatbelt evidence, seatbelt non-usage evidence, is prejudicial. And I want to talk a little bit about that. That determination, supposedly reflected in the current statute, that current statute was enacted in 1988, and a lot has changed since 1988. When it was enacted, the usage rate was 45%. People didn't know, people didn't understand, people didn't trust seatbelts. People thought it was better to be flung free of a car than to be belted and ride down the crash. Since 1988, that has been conclusively proven wrong by the National Highway Traffic Safety Administration, CDC, and others. And most importantly, people in Georgia recognize that. That is why we heard the statistic that we just did. Instead of 45% usage rate, now it's 95% usage rate. That's because the policy of wearing seatbelts has been embraced. The other suggestion that you have heard is that seatbelt evidence is somehow prejudicial. It's imbalanced.
Got 10 seconds.
To allow the jury to hear that. It's unfair to defendants who did not cause those injuries to not let them hear that evidence. And in terms of other states, Louisiana has repealed their rule.
Thank you.
West Virginia and others. Thank you.
Senator Watson, you can step back up. Yeah, I was going to ask you if you could opine, perhaps more briefly than you just did, on the evidentiary rules around seatbelts were this law to be enacted as it's before us today.
Sure. So I think the question was related to the troopers and how do they come up with their determination. I think my understanding is troopers and officers base their determination, how they mark that box, based on a totality of circumstances. Did they see the driver or the occupant? Did they hear from the EMT that the person was unbuckled? Was the belt cut? Things like that. But that evidence is not determinative. What the trooper says is not the answer. So there's all kinds of other evidence, most notably the EDR in the vehicle itself, which has been required in every car sold in this country since 2013. It's easily downloadable. Most police officers have that capability, and
Thank
that
you.
definitively answers it.
I'm going to go to Senator Mallow. We have 6 minutes before we lose this room, so let's keep our questions and answers brief, please. Senator Watson, if you don't mind stepping back up. Thank you.
Thank you so much. Question, as you talked about the seatbelt and the determination of the trooper, doesn't that put the trooper in a position of potentially hearsay if Senator McLaurin said he didn't see me wearing the seatbelt, I said that I was wearing my seatbelt, and the trooper is going to have to assess which one of us he believes to make that determination, or whatever law enforcement officers on the side of the road?
In terms of what the trooper puts down on the form, thank you. Yeah, I mean, he's got to make a determination based upon the evidence that's available, but it's not the trooper's form that controls the issue. When it goes to the jury, and that's what this bill is all about, we're looking at the totality of the evidence, all the different evidence that comes in.
And a further follow-up, so if you were...
Does that include the electronic recordings that you're talking about? So, listen, I get it. There may be a question there, but it's not going to be the question on the electronics, right?
Gotcha. But my follow-up is, then is it admissible for the citation if the driver was cited at fault for the accident? Is that going to also be admissible in court to know that you did cause the accident?
No, because the actual conviction or the citation doesn't relate to the actual facts of the accident. That's a separate legal determination. What matters in a jury verdict in a civil case is what happened in this crash. Did somebody run a red light? We have to enter evidence about
so
what
the
happened.
simple answer is that criminal versus civil.
I appreciate the doctor intervening there on behalf of the lawyer.
Much appreciated.
For brevity. Senator Moore, you've got 20 seconds, and we're going to take the will of the committee.
My understanding, if I'm not wearing a seatbelt and I go through a red light and I'm T-boned, I'll go through a green light and somebody runs a red light and they T-bone me, they're at fault. Okay, the fact that I wasn't wearing a seatbelt is going to make it more difficult for me to sue the person who was actually at fault and T-boned me.
No.
Under this legislation.
No, you can still sue. It's just a determination of what damages are caused by the other driver and what damages resulted
So
from.
would the fact of me not wearing a seatbelt be causation?
It could be causation. It could be mitigation of damages. It could be comparative fault. It
Okay.
could be any of those.
All right, thank you, Mr. Mickes. What is the pleasure of the committee?
Could I have a little follow-up, or?
Yeah, you may. I
do we have-
apologize.
No problem. Listen, this is a loophole that was placed by Speaker Murphy because he was a trial lawyer, what was that, 25, 30 years ago. That's where it derives from. This is putting the scales of justice relating to a loophole in the law. That is all it is. And the electronic determination in a civil case is not the criminal case. Two separate issues. This is making justice right from a scales of justice gone wrong. And that's what it is. And to answer your question, we've talked about this before, Senator Moore. If you're not wearing your seatbelt and you lose control of your car or truck, and you're using that steering wheel to hold on to rather than being ejected out of that car, and you hit me and my family and cause injuries to us, well, shame on you for not wearing your seatbelt. I mean, goodness gracious, you should have been, if you lose control of a car, you should be steering to try to get out of control of that and not hit me and my family. I just don't think that's right. And last point I want to make, and I apologize for getting emotional
You're about to lose
here,
your room, Senator.
is the active participation of eluding that electronic thing and latching it behind you or putting things in the object that are sold online so that it looks like you are wearing the seatbelt. With that, I apologize and thank you for your consideration.
Thank you, Mr. Chairman. Recognize Senator Anna Vitarte.
Mr. Chairman, make a motion to pass Senate Bill 196, LC 39377-8S.
We have a motion to pass, and we have a second from Senator Ginn. Any discussion from the committee? Yes. I got a couple of lights. Senator Moore.
Yeah, so, I mean, if you're not wearing a seatbelt in the state of Georgia and a trooper pulls you over, it's like a $15 or a $20 ticket. So that's about the standard that we think that's important as a state. But yet, if I'm not wearing my seatbelt and someone runs over me and I want to take civil litigation to them and say they've done great damage to my vehicle or whatever else, it's a little bit more than a $20 ticket. And if it's going to be causation, if the fact that I'm not at fault, but I'm not wearing my seatbelt is going to limit me from suing to a maximum extent.
I don't mean to
Yeah.
talk over you. I apologize about that. It does not limit you from doing that. You're still able to do that. He answered you honestly. Could it mitigate how much damages you get? Well, yes. Right, it should.
All right, we have a motion and a second. All those in favor of the motion, please signify by raising your hand. Five, I believe. Can somebody double check my count? It's five, correct? All those opposed, like sign. 7. Motion fails. Thank you, Senator Chairman Watson. Thank you, everyone, for attending the committee meeting today. This meeting is adjourned.